If you're a green card holder, whether you've lived in the US for years or you're still waiting to apply for citizenship, you need to listen closely. Many permanent residents have worked hard, paid their dues, and carefully prepared their cases. But beginning September 1st, a powerful new USCIS rule is taking effect, and it carries consequences that could end a person's future in America. Under this update, any green card holder who voted, attempted to vote, registered to vote, or falsely claimed citizenship now faces automatic deportation and a permanent bar from naturalization. What makes it even more alarming is its retroactive reach, meaning even mistakes from years ago can now resurface with devastating impact. We're not here to scare you. Our goal is to make sure every permanent resident understands exactly what's changing and how to prepare. In this video, we'll explain what the new USCIS rule actually says, how officers are enforcing it, who is most vulnerable, and what steps can help protect you from unexpected removal. Let's dive right in. The rule that changes everything. The new USCIS policy, officially rolled out in late August 2025, but fully enforced beginning September 1st, represents one of the strongest crackdowns on green card holders in recent memory. Under this policy, any act of voting or claiming U.S. citizenship, no matter how small, unintentional, or long ago, can now trigger deportation proceedings. The change comes as part of a broader immigration enforcement push by President Trump's administration. According to USCIS, the agency is now under strict orders to screen for non-citizen voting across all immigration applications, not just during naturalization interviews. That means when a green card holder applies for citizenship, renews their green card, or interacts with USCIS in any way, their records can be checked against state and federal voter databases. So, here's the bottom line. What used to be up to an officer's discretion is now a strict mandate. Officers just don't have any leeway to think about the context anymore. If the records show voting, registration, or any claim to citizenship, they have to deny the case and issue a notice to appear in immigration court. Why does this matter? Well, federal law has always made it illegal for non-citizens to vote in federal elections, and honestly, it's been grounds for deportation for a long time. But historically, immigration officers would often look at whether something was intentional fraud or just an honest mistake. A lot of cases involved non-citizens who accidentally registered at DMVs or misunderstood forms, and those usually didn't lead to removal. Now, with this new USCIS rule, that kind of discretion is gone. The agency's been told to treat every case of voting or a false claim to citizenship as a violation of good moral character, period. Without good moral character, citizenship applications get denied outright and deportation proceedings start up. So in short, if you're a permanent resident, even one mistaken checkbox on a form could end up costing you not just your shot at citizenship, but also your place here in America. So here's how USCIS is actually enforcing the rule. USCIS has expanded data sharing with state election offices and the Department of Homeland Security. Officers now have access to voter rolls, registration data, and even past applications where folks might have checked U.S. citizen by mistake. When evidence is found, officers have to deny the application, issue a notice to appear, and in some cases refer the matter for criminal prosecution. According to DHS, these cases are going to be a top priority moving forward, and every applicant is now screened for signs of non-citizen voting or citizenship claims. This approach is, part of the administration's zero-tolerance model. In fiscal year 2024, DHS reported over 359,000 arrests and 332,000 removals. With new funding from the One Big Beautiful Bill Act, which was signed on July 4, 2025, enforcement is only expected to expand. Retroactive reach while old mistakes still count. One of the most alarming aspects of this new policy is, honestly, its retroactivity. USCIS officers are instructed to apply the rule no matter when the act occurred. That means a green card holder who registered to vote 10 years ago or who was automatically registered at the DMV without even realizing it can still face denial and removal today. Examples include a lawful permanent resident who filled out a form for a driver's license and, mistakenly checked the U.S. citizen box, someone who registered to vote through an automatic state system without fully understanding the implications, or a person who never voted but whose registration still appears on state election rolls. Under the current rules, these scenarios are treated no differently than intentional fraud. Legal challenges and lawsuits. Civil rights groups, immigration advocates, and 19 Democratic attorneys general have already filed lawsuits challenging the policy, arguing it oversteps federal authority and risks punishing innocent people. Several provisions of President Trump's March 2025 executive order on election integrity have already been temporarily blocked by the courts, particularly those concerning voter ID rules and presidential authority over election processes. So, USCIS has made it clear that the core rule about non-citizen voting and deportation is still in effect, unless and until the courts strike it down. What that really means is, green card holders are, vulnerable right now. Immigration attorneys are warning that even if those lawsuits eventually succeed, cases started under the current rule could actually take years to resolve, with families just caught in the middle. Now, who is most at risk here? Well, the people most vulnerable under this new USCIS policy include green card holders who, maybe without realizing it, registered to vote at a DMV or state agency. There are also permanent residents who voted in local or state elections, not realizing that federal law bars non-citizens from any election involving federal offices. Plus, there are folks who checked U.S. citizen on any government form, whether it was for employment, a driver's license, or a passport application. These individuals may not have meant to break the law, but under the revised USCIS instructions, intent just doesn't matter anymore. The mere presence of these records is actually enough to derail their case. Okay, here are some practical steps to protect yourself. Immigration lawyers really emphasize that green card holders shouldn't wait until, they're in an interview to discover there might be problems. So, the steps you can take include, first, request your voter registration record from your local or state election office, and then confirm whether your name appears on the rolls. If it does, you need to seek legal guidance immediately on how to correct it. Second, consult an immigration attorney before filing for citizenship if you have ever registered or even suspect you may have been registered. Don't assume that USCIS is just going to overlook the issue. Third, prepare carefully for all USCIS interviews. Officers are now trained to ask detailed questions about voting history, citizenship claims, and even minor paperwork errors. If you are uncertain about your past records, discuss them with a lawyer before the interview. Finally, avoid guessing or making assumptions during interviews. If you do not know an answer, say so and be prepared to provide documentation later. So, what this means moving forward is that, this crackdown really signals a broader shift in U.S. immigration policy. We're talking about less discretion, harsher consequences, and expanded data sharing between agencies. For lawful permanent residents, the message is clear. There is simply no margin for error when it comes to claims of U.S. citizenship or voting. While lawsuits could eventually scale back parts of this policy, USCIS has the authority to enforce it right now. That means green card holders really have to be proactive. Understand your history, correct any mistakes, and, prepare for those interviews. Attorneys say the most important step is awareness. Many people at risk may not even realize they are vulnerable until it is too late. By knowing the rules, reviewing your history, and seeking help when needed, you can, reduce the chance of being blindsided. So, long story short, beginning September 1st, the landscape for green card holders is changing dramatically. What used to be overlooked as an honest mistake is now treated as a deportable offense. Voting, registering to vote, or even accidentally claiming U.S. citizenship can trigger immediate denial and removal. The stakes are higher than ever and the consequences are permanent. This is not about fear, it's about being prepared. Green card holders need to know the risks, review their records, and take action now to protect their future.